sweetie, goodbye. Good, sweetie, don't cry. The little choo-choo train that takes me away from you. You don't know just how sad it makes me. Kiss me goody and then out, do it over again.
I am asking for your help because you have the power to stand up to the power that is overwhelming me, the virtually monolithic power of the state bar. I have practiced federal immigration law in the Los Angeles area as a California attorney since 1993. In recent years, I became overextended mentally and physically, and I voluntarily stipulated to a 2-year suspension of my practice for rehabilitation. But the order starting my suspension was never sent to me by the court, the California Supreme Court, and so I missed the Rule 920 affidavit filing deadline by no more than 26 days.
And so began Jack's disbarment nightmare. The seeds for it were sown decades earlier when he was a young man in love.
So really my involvement in immigration law stems from this Romeo and Juliet situation I got myself into as a young man. I was 19 years old when they shipped me out to Berlin. And my girlfriend was like all of 3 months older than me. And it turned out that she was from the Republic, not from Berlin. So I got her to move to East Berlin at least, but we had to live in a bootleg apartment that doubled as an artist's bootleg studio. Right under the takeoff zone for the jets from Tempelhof in West Berlin, they'd zoom over our apartment in East Berlin. I had to check in with the police every day, but they were letting me out on a 24-hour pass for Berlin.
After returning to the United States, Jack graduated from law school and passed the bar exam. He practiced law for more than a decade and a half before he agreed to be disciplined with a 2-year actual suspension. A suspension takes effect 30 days after the California Supreme Court enters its attorney discipline order. The Supreme Court is supposed to mail a copy to the suspended lawyer so that he or she knows when the 30-day deadline expires.
The clerk of the Supreme Court will mail notice of this effect to the member and his or her attorney of record, if any, at their respective addresses.
When Jack's suspension began, he was required to fill out a printed form attesting that he had stopped practicing law. It is known as a 9.20 affidavit. The state bar prosecutors accused him of submitting his affidavit a month late, and on that basis, they filed a new disciplinary charge in early 2011. The case was assigned to Los Angeles State Bar Judge Donald Miles. Jack did not agree with the prosecutor to be punished with an extra year of actual suspension because of the late form. The prosecutor therefore demanded that Jack be disbarred. Jack's defense in State Bar Court was that he had not received a copy of the Supreme Court's order as he was supposed to.
I've never received a copy of my order from the Supreme Court. The Supreme Court never sent me directly its order. I did call the Supreme Court clerk's office and investigate as to what proofs they had that they had ever sent anything. I would try several times a day and catch a different clerk answering the phone, and one was very cooperative and dialed up my case on the computer and started reading me off the addresses of my attorney and some sort of a note that I think something had been sent to my attorney, but nothing was ever sent to me in his records.
At his state bar trial, Jack stated that he had not received a copy of the Supreme Court order from his lawyer, and his lawyer did not testify that he actually remembered seeing a copy mailed to Jack from his office.
So I set about crafting the subpoenas to the personnel in the clerk's office that I learned had to do with my case, and also a general one for the custodian of records, and had them formally served by a process server on the Supreme Court clerks. And that's what provoked the intervention of this private attorney, Sarah Overton, on behalf of the clerks of the Supreme Court to prevent them from giving evidence at my hearing.
In her letter, Miss Overton seemed to acknowledge that the clerk had only mailed a copy to Jack's attorney, with no copy directly to Jack as required by the rules of court. Jack testified that the first time he saw a copy was in late November or early December, buried in a packet of documents that had been mailed to him by the State Bar's probation department. Jack also pointed out that the California Supreme Court clerk had never prepared a proof of service. A proof of service is a document that clerks and lawyers attach to legal papers to prove that the papers were mailed to the required people. Judge Miles recognized that Supreme Court clerks do not execute proofs of service for those kinds of disciplinary orders. Despite all of this, Judge Miles made a finding.
Under Evidence Code Section 664, it is presumed that official duty has been regularly performed.
In other words, Jack must have received a copy directly from the Supreme Court because the California Evidence Code presumes that officials always do their jobs properly. Judge Miles used this legal fiction to recommend Jack's disbarment, even though the clerk's own attorney seemed to confirm what Jack had said, that a copy had only been mailed to his attorney. Judge Miles also recommended Jack's disbarment because Jack had made his last court appearance on behalf of a client on October 15, 2010. This was the date that his suspension was supposed to begin.
Failing to receive the formal order from the Supreme Court, but apprehensive that it was soon to come, requiring me to cease practice, I voiced such concerns to another lawyer. She went to the computer, looked me up on the State Bar site, and printed out my webpage, my membership page, which stated that I was eligible to practice law. Now, it was a small note in there on that page that stated my actual suspension to begin October 15. So, mindful of that date, I scheduled the surrender of a fugitive in Fresno that I drove to twice that week, October 12th, to file the motion, and the 15th to actually produce the fugitive. If I had the ineligible flag on that page that morning, I would have had a lot of problems, or I would have had to instruct my client to go in alone. And I know she didn't want to do that. I drove to Fresno from LA early in the morning on the 15th, and I pulled into Starbucks just before I went to court, and I got online. I looked up my webpage on the State Bar, and it said the same thing it had said in late September when this other attorney had given me the page. It said I was eligible to practice law. Active, eligible to practice. Now, it still had the little note about October the 15th, actual suspension. And I'm looking at, it's October the 15th, but I'm still eligible, so I felt good about going to court, but I kind of reasoned that, well, if it starts today, it must start late today. It's Friday, October the 15th. And on the second page of the webpage, there was another little note, something about some obligation beginning 10/16 at 2010, which is a Saturday. But that logically made sense. Well, if the 15th is the last day, then the suspension formally begins the 16th.
To many observers, it would appear that the confusions in Jack's case were caused by clerks at the California Supreme Court and State Bar. The Supreme Court clerk had not mailed a copy of the notice directly to Jack as required by law, and the State Bar website stated that Jack was still eligible to practice law on the morning he went to court. So why should Jack be disbarred for that?
It was beyond the realm of what I thought possible. Worst case scenario. The fact that I would be disbarred.
Judge Miles made a finding that the late filing of the 9.20 affidavit caused no harm and that Jack had substantially complied with the deadline to stop practicing law as of October 15, 2010. Despite these favorable findings, Judge Miles went along with the prosecutor.
The system itself stands in need of rehabilitation. Therefore, I implore you to stop measuring the performance of the State Bar and rewarding them according to the quantity of attorneys disciplined, and rather to inquire into the quality of that discipline.
The State Bar's difficulty in trying to be both a disciplinary body and a trade guild was perhaps no more apparent than in the case of Richard Fine. Richard was a respected Beverly Hills attorney who tried to stop the County of Los Angeles from making illegal payments to state judges. Instead of coming to his aid like a trade guild might do, the State Bar took away his law license.
Tonight, a KNBC investigation into long-standing financial ties between the county and local judges that some say have upset the scales of justice. Channel 4's Paul Moyer has the story.
Los Angeles has the best courts money can buy.
Activist John Rizzo is worried about potentially corrupt judges in Los Angeles County. He says if you try to take the county to court over child custody, property rights, a criminal matter, or if you sue the County Board of Supervisors, you're going to lose. Because, he says, the judges handling these cases are feeding at the county trough.
It's hard enough fighting all the big boys without the judges getting monies from the people that you're fighting. I think it puts a dubious cloud over the entire system.
Attorney Sterling Norris shares Rizzo's concerns and says local judges are being tainted by special financial benefits they get from Los Angeles County.
They are the final arbitrators of justice, and they should have the cleanest hands of all.
Some background. In 1998, the state legislature took over the funding of local courts, giving Sacramento the responsibility of paying the salaries and the benefits of state judges. Benefits paid by the counties were supposed to be phased out. One county hasn't gotten the message.
They forgot to turn off the till in Los Angeles County.
While every other county in the state has stopped paying judicial benefits or is cutting back on them, L.A. County is still giving local state judges a big double dip. $40,000 in extra health and training benefits. $40,000 for each judge each year, in addition to the six-figure salaries plus benefits they get from the state.
These judges are paid on top of every other Superior Court judge in the state of California, this $40,000 extra.
Norris says these payments compromise the judges and create a conflict of interest for them. Richard Fine, another local attorney, agrees and says there's no limits on how the handouts are spent.
The judges can elect to either spend the money for their professional development or to buy county insurance, or they can just take the money, put it in their pocket, and spend it any way they want.
Fine says the payments make local judges among the best paid in the United States and cost L.A. County $21 million a year, this in a time of budget crisis. But the real scandal, he says, is that the judges can pocket the money without having to disclose it to the public.
The average person going into court against the county will never know that the judge is receiving money from the county.
And how does the money weigh on the scales of justice? Fine points to a recent case involving Marina Del Rey and resident John Rizzo. Rizzo, represented by Fine, sued L.A. County and various developers over the leasing of public land in the marina at prices that Rizzo says shortchanged the public.
The county administers the marina.
The judges ruled against Rizzo. He says it's because the judges were sucking up to their county paymasters.
How can they take money from somebody you're suing and render a just decision?
Fine says the marina case is not unique and notes that in 2007, no one who sued L.A. County won his case when the decision was made by the judge alone.
This means that $40,000 has an effect.
Fine has repeatedly sued state superior court judges for taking the extra payments and not disclosing them. And Norris's law firm Judicial Watch has sued L.A. County for making the payments. But, says Norris, taking on the county and the judges this way can be costly to a lawyer.
There's a real fear some of those judges would retaliate against your law firm, retaliate against you in some sense for doing it.
Norris says 3 law firms were too afraid of retaliation to assist in his lawsuit, and Fine is facing possible loss of his attorney's license in an action brought by the State Bar of California before the State Bar Court.
Mr. Fine's conduct in this proceeding amounts to aggravation.
In this review hearing, attorney Kevin Taylor, representing the State Bar, accused Fine of filing frivolous lawsuits about the payments issue to harass judicial officers who ruled against him in other cases.
There is nothing here showing that there is any frivolous litigation or anything else.
The review judges, who were not from L.A. County courts, ultimately ruled against him and recommended his disbarment. He says he'll fight on. Meanwhile, the Norris litigation has been up on appeal in San Diego, beyond the reach of the judges of L.A. County. Last Friday, the appeals court ruled in Norris's favor, making payment of L.A. County benefits to local judges illegal.
These payments should never have been there. I mean, the judiciary ought to be above any kind of question.
According to the appeals ruling, the California Constitution makes it very clear that only the state legislature can prescribe compensation for judges. The court said that the L.A. County benefits are, quote, not permissible. Paul Moyer, Channel 4 News.
The State Bar Court's Review Department recommended that Richard be disbarred less than a month before the appeals court issued his ruling in the Judicial Watch case, the case of Sturgeon versus County of Los Angeles. After the Sturgeon case vindicated Richard's position about the illegal payments, he asked the review department to reconsider his disbarment recommendation. The review judges refused. The California Supreme Court declined to hear Richard's appeal and ordered his disbarment on February 11, 2009. In the meantime, Judge Yaffe of the Los Angeles County Superior Court held Richard in contempt after being ordered to pay sanctions in one of the cases involving Los Angeles County. Richard was imprisoned at coercive confinement. He served a year and a half in solitary at the Los Angeles County Jail. Did the California Chief Justice Ronald George, who signed Richard's disbarment order, have a conflict of interest in disbarring Richard? An organization called the Judicial Council of California sits in the same office complex as the California Supreme Court. The Judicial Council describes itself as the policy-making body of the California courts. The Council's official mission is ensuring the consistent, independent, impartial, and accessible administration of justice. The Judicial Council often proposes and takes positions in regard to legislation that affects the California court system. The chairman of the Judicial Council is the California Chief Justice, who at the time was Ronald George. When the Sturgeon ruling came out in 2008, the Judicial Council under Ronald George's leadership took quick action. It proposed new legislation to make those payments legal retroactively. The bill also granted immunity to all judges who had accepted the payments during the time that it was illegal to do so. At the same time, Ronald George was sitting atop the organization, the State Bar, that wanted to disbar the very lawyer who fought against those payments. The close relationship between the Judicial Council and State Bar can also be seen in their memberships. Today, former Judicial Council member Joe Dunn is the executive director of the State Bar. Former State Bar trustee Angela Davis recently began serving on the Judicial Council. Some observers say that the Richard Fine case is a vivid example of why the California Supreme Court should not be involved in lawyer discipline. The Supreme Court's role in the Judicial Council puts it in a position of looking out for the welfare of judges. Yet, many state bar discipline cases are filed because of conflicts between lawyers and judges. Most judges are conscientious, hard-working people, but judicial misconduct does sometimes happen. Lawyers are in the best position to spot it and to try to do something about it. But if the state bar punishes those lawyers with discipline instead of trying to help, is not the public being harmed? As critics point out, Richard's disbarment was good for the state bar and the Judicial Council. They were rid of a nuisance lawyer who had threatened the judges extra money, and the bar had another disbarment statistic to show the legislature. And how much did the bar charge Richard to take away his law license? Jeff Lustman is a licensed California attorney and private investigator who can sometimes be found after work singing karaoke at the Happy Ending in Hollywood. Jeff has run for election to the State Bar Board of Trustees. His bar activism began as a result of representing a woman named Shirley.
I had to file a lawsuit in civil court for Shirley because of the abuses that went on by Los Angeles County and by the hospital and by some others involved in this. She was inappropriately put on the conservatorship. Well, in Los Angeles Superior Court, David Wolf was the judge. He's since passed on also in 2010. And he was making rulings in favor of the county, which didn't make sense. I told my client, I told Cheryl, this judge is making rulings that don't make sense. I didn't know what was going on. I appealed it to the California Court of Appeals. When I was having oral argument, one of the judges who said there was a trial, I said to him, it was Judge Rubin, Lawrence Rubin, I said there was no trial. About a minute later, again, he refers to the trial. He might have said court trial, but he refers to the trial. And I said to him again, there was no trial. I don't know what's going on. Then I get the decision back claiming that there was a trial. There was no trial, and I don't know what's going on. All you have to do is read the complaint. There was no trial. I appealed to the California Supreme Court to overturn what the Court of Appeals had done. The California Supreme Court refuses to hear it. Okay. I'm relatively inexperienced. I don't know what to do. So I call some attorneys. What do I do after this? I mean, do I put it in federal court? What do I do? And 3 or 4 attorneys told me that the Court of Appeals makes things up. One attorney told me is if the story as recited back by the Court of Appeals was the actual story in the case, he wouldn't have taken it in the first place. Now, this is more bewilderment. It's like, how long has this been going on? Because there's more than one attorney who's telling me this. Where's the state bar? The Court of Appeals is making stuff up. Okay, so in my case, I had thought maybe it was an honest mistake. It turns out they lied. They lied to protect the county. Why are they protecting the county? I didn't know that judges in Los Angeles County were taking illegal payments from the county, even when they had a county case in front of them, a violation of the canon of ethics. I didn't know any of this stuff until I got involved. So what do? I wanted to write a nasty letter to these 3 lying judges. I was afraid I'd get in trouble with the state bar. I didn't have really ethical problems with my writing that letter. I'm going to call the ethics hotline. See, the ethics hotline, run by the state bar, is telling me about freedom of speech, and I'm telling them stuff, points I want to put in, and they're telling me about the Steve Agman case and freedom of speech, and it's all that. They're not telling me a single thing which would get me in trouble. It's okay, good enough. I called them before I wrote the letter, then after I wrote the letter, I called them again because I had it in front of me. And again, I talked to a different person who's saying, no, free speech, and you can't demand you can't demand they change it and then threaten that you're going to do something. And I wasn't doing it. I was just writing to some. I don't appreciate it. And I wrote this somewhat nasty letter. Here it is. This is the magic letter that got me in trouble. So the letter goes from the Court of Appeals to the state bar. I get a letter from somebody who works at the Court of Appeals. And we're sending this to the state bar. Okay, whatever. I sent him back a letter. I said, well, I already called the state bar and I've already cleared stuff or whatever I said with this letter. Just want you to know. Well, the state bar comes after me and they decide they're going to discipline me Anyway, I explained what happened. I was going by, your ethics hotline for me. So anyway, I'm disciplined. We settle on a public reproval. There's nothing I can do. They pull the rug out from under me. I get a bill for about $1,983 later on. I didn't know until I got the bill, and I realized all of a sudden, wait a minute. This is a rip-off operation. The State Bar is using the discipline system to rip people off, including me.
You cannot trust these employees of the State Bar of California. The State Bar Court has a complete conflict of interest.
The problem with the State Bar, it's not just that it's a common sense conflict of interest. If you take a look at the California Constitution, Article 1, Section 16, trial by jury is an inviolate right and shall be secured to all. Okay, it's right in the California Constitution. The Business and Professions Code, any person complained against, that's a reference to the State Bar, shall be given fair, adequate, and reasonable notice and have a fair, adequate, and reasonable opportunity and right. And down in this is Section 6085, down in Section E, to exercise any right guaranteed by the California Constitution or the United States Constitution, including the right against self-incrimination. Well, the California Constitution itself says that there's trial by jury is an inviolate right. The State Bar violates that. The state Supreme Court, if you're wondering where they are on this, the state Supreme Court uses the State Bar as its administrative arm. Now, for the state Supreme Court to allow this stuff to happen, you have to think that they did not know about the jury trial right. Why would the state Supreme Court know about the jury trial right? After all, they're only judges in the state Supreme Court. They don't know this legal stuff. Perhaps they've never read the California Constitution. This is what has been going on. Security people need to see the flyer. No steps. Well, when you're up against a State Bar, when they're disciplining you, and they're going to try to get money from you, you're up against the first or second biggest organization of lawyers in the United States. But to them, that's not enough advantage. They have to make sure all the triers of fact work for them. All the triers of fact work for the State Bar. They're judges, but they work for the State Bar. It's a complete conflict of interest. And it's going to be, it's kind of like getting hit by a bus and you look out at the jury and they're all employees of the bus company. Before I got involved in this, I did not know what was going on. I see things, I think it's a State Bar Journal, whatever it's called, which talks about the discipline of attorneys. All these attorneys seem to be just like evil and wrong and all this other stuff. And it did not occur to me till my case. When the Bar Journal writes up these things, they're not necessarily asking for the attorney for his side. Because mine was not a suspension, it was a public approval, I was not written up in the Bar Journal, but I was written up in California Lawyer Magazine. One thing I noticed in California Lawyer Magazine, when they were writing about me, it did not say a word that I was going by the ethics hotline. And that's when it first hit me, and maybe it should have hit me years earlier. The California Bar Journal and the California Lawyer Magazine, apparently, at least in the great majority of cases, are not contacting these attorneys to ask their side. So when you read about this evil attorney who did this and did that, you're getting the California Bar's side. You're not getting the attorney's side. I always kind of assumed, I took it as gospel, this is what this attorney did, no mitigating circumstances, or they would have said it. Well, apparently that's not the case. I had no idea this stuff was going on, and I think a lot of people who are abused by the State Bar are shocked when it happens, because I had always thought of the State Bar as a place of integrity. I was mistaken.
Cost assessments against disciplined attorneys have been controversial since the law was first approved in 1986. Even the California Supreme Court had rejected such a proposal 2 years earlier. The law passed anyway. Legislative documents reveal the thinking behind the law.
The purpose of this bill is to shift the financial responsibility for disciplinary proceedings from the bar to the attorneys being disciplined.
The bill's supporters say state bars in 33 other states are permitted to recover disciplinary costs.
The potential for expensive disciplinary proceedings could serve as a deterrent to unscrupulous behavior on the part of some attorneys.
The threat of a lengthy and expensive trial may encourage some attorneys under investigation to cooperate earlier in the procedure in order to minimize their potential financial liability.
But were all of these motives proper? Critics say that the bill was intended to create a form of financial coercion that could be used to pressure lawyers into stipulating to disciplinary charges. But what if the charges are inaccurate or unfair? Even some state bar officials criticize the legislation.
Some bar employees and observers question the practicality and propriety of requiring disciplined attorneys to bear the costs of their proceedings.
These critics compare such a procedure with requiring criminal defendants prosecuted in state courts to reimburse the state for its costs of investigation and prosecution. That system, they argue, would be unfair and unconstitutional.
Just a few years later, the legislature passed another law that permits the California Supreme Court to assess direct fines against suspended or disbarred lawyers. These fines are in addition to the cost assessments. The fines can be as high as $5,000 per violation, with a total limit of $50,000. In 2003, the bar convinced the legislature to amend the law to say that cost assessments are also considered to be fines and penalties. That way, cost assessments cannot be discharged in bankruptcy. This change to the law was tested in the federal court by disciplined attorney John Findley. He had tried to include his cost assessments in a personal bankruptcy. We met with John to talk about the legal battle with the bar. He began by explaining the discipline case.
I considered I was being bullied, and I fought tooth and toenail against the state bar every step of the way. But when the state bar is the prosecutor, and the state bar is the judge, and the state bar is the appellate level, you are definitely fighting an uphill battle, and you're not going to win. They basically do whatever they decide they're going to do. And if you are defiant, which by the way was something that was even mentioned in my most recent decision from the state bar court, was that I was still defiant. They take that as an affront and they use it against you. So they chose to take my bar license for 30 days, which by the way, when we had a settlement, I had agreed to 30 days.
As John quickly found out, a 30-day suspension can last much longer if the state bar does not get the money.
When they ruled against me and I knew when my 30 days started and finished, immediately after the end of my 30 days, I had a trial set in Sacramento, which I intended to go and attend because my suspension would be over. They dated on the date that my suspension started, which was December 16, a letter advising me that unless I paid in entirety the amount they claimed I owed them for fees, that my suspension would continue until it was paid. However, they did not mail that until a few days before the end of the 30 days. They held that letter for over 3 weeks. I received it on Friday with a trial set for Monday. So on Friday, I became aware of the fact that they still considered me suspended. I contacted the client, and I went with that client to court to advise the court that I was under suspension and would not be able to represent them. Had the client request a continuance of the trial, which that judge, for whatever reason, chose not to grant. I don't know what happened to that client, but I'll guarantee you they were harmed a lot more by suddenly being left with no attorney at the last second than any client I ever represented or any mistake I ever made during 14 years of practice. I had filed a bankruptcy. I went through a divorce, went through fighting with the state bar, filed a bankruptcy. So I raised the issue, and I had also researched this, and the governing decision on that issue was Taggart versus State Bar of California, Taggart. And in reliance on that, I filed and sought to have their ridiculous charges dismissed or discharged in bankruptcy. So they decided to challenge me on that in bankruptcy court and filed a motion to have it determined that those charges were not dischargeable. I appealed to the bankruptcy appellate panel and was successful at that level. They overturned the trial court, ruled in my favor. And what I thought was a well-written and very detailed decision. The State Bar Court then appealed to the Ninth Circuit Court of Appeal, who, much to my surprise, overturned Taggart and decided that the new legislation, which stated that the legislature's purpose in passing the prior legislation was different than what they had previously decided. So we have legislation that's written by the State Bar that is pushed through the legislature with a tagline that says this does not change existing law. And logically, the only purpose for putting that there is to tell everybody in the legislature, you don't really have to look at this. You don't really have to think about this because we're not really doing anything here. And so they passed it. And then the appellate court says, well, yeah, it says that, but it really does do something. And that tagline that says it doesn't, we're going to ignore. And we're going to overturn our previous decision in Taggart. And we're going to say that the State Bar charges are non-dischargeable in the future. Now, when they passed that legislation, they also got a change which says that those fees are collectible as a debt. So even if they take your license, they can pursue you to the grave to collect their money. It's all about the money. And I was actually contacted subsequently by a former attorney who is 81 years old, had a 19-year-old case with a judgment against him. And with that change in the law, they were pursuing him to collect that judgment.
At a hearing in the Oakland Bankruptcy Court, a lawyer representing the bar said that the State Bar uses cost assessments as a tool to prevent lawyers from returning to law practice.
The purpose for the imposition of costs is to, as part of the disciplinary process, and to put, in essence, a brake on a attorney who's committed misconduct from regaining access to the practice of law.
Another State Bar prosecutor revealed even more to John.
One of the things that she said, which I found completely shocking, was that the State Bar needed these fees to be imposed and to not be dischargeable so that they could weed out undesirables. And that is not the official purpose of those fees. And although it took a while for me to actually think about that comment and decide just exactly what I thought about it, it occurs to me that undesirables is a term that have been used by oppressive groups and peoples throughout history, that in this context, there are no rules about weeding undesirables out of the State Bar. If they've done something that's a disbarable offense, there are procedures for finding them, trying them, and disbarring them. So if they're weeding people out as undesirable, that means that's people who have not committed a disbarable offense. It means it's people who owe them money, and for no other purpose than the fact they owe them money and for whatever reason they're not paying it. And that some unknown person within the State Bar has, for whatever reason, decided that this person is undesirable. They're going to hound them out of the profession. So it's evidence. To me, it's clear evidence that there's a systemic attitude problem within the State Bar, and it is affecting a lot of people at a fairly high level. And they have decided that they are going to decide who gets to practice law and who isn't by their own standards.
What does it take to be considered an undesirable by the State Bar? Sometimes it can be little more than disagreeing with the legal opinions of state bar court judges, as another disciplined lawyer found out. Meet Brad Henschel. In 2003, he had agreed to an 18-month actual suspension in a discipline matter. Brad later discovered that 18 months could actually mean indefinite suspension because of a state bar rule called Standard 1.4 CII.
I took their deal, and they put down a 1.4 CII standard on me, which he said was no problem. The 1.4 CII standard now is being used by the state bar to disbar people by suspending them forever, or until they die, whichever comes first.
After serving his 18-month actual suspension, Brad petitioned the state bar court to be allowed to return to practice. Bar prosecutors opposed Brad's petition and wanted to keep him suspended. The matter went to former state bar court judge John Talcott, who decided in Brad's favor. The prosecutors were not happy with Judge Talcott's recommendation, so they appealed to the review department. In a surprise move, the review department reversed Judge Talcott and recommended that Brad remain suspended. This was made into a published review department opinion, which means that it can be used as precedent in future state bar cases. We met with Brad on a second day to talk about the review department opinion. The review judges set forth multiple reasons why they felt that Brad was unfit to practice law, reasons that can be used against other lawyers in the future. For example, Brad had tried to set aside the stipulation in which he originally agreed to the 18-month suspension.
The attorney is unfit to practice law because he continued to reject the truth of the facts and legal conclusions contained in his stipulation.
What I did was I took the rules and I put it next to this complaint, or the stipulation rather, and I found 32 errors. Most were major, a few were minor, and I asked that it be changed because it was wrong. They write it up by hand and put it in front of you and say, take it or leave it. And while you're thinking about signing it, they've written down that it's going to be a year and a half, because it started out to be a year. It first started out to be 2 months. What the bar attorneys do is they say, well, we're going to make it more years of suspension, and we're going to go for disbarment if you don't sign it right now. And they pressure them, and they put them under stress. So when they're writing in what's called errors, those are deliberately put in order to meet the factual requirement of all the elements for that ethics charge.
Petitioner telephoned and wrote numerous letters and emails to various state bar employees, department heads, and the Office of Chief Trial Counsel, asserting that trial counsel suborned the perjury of a witness.
They completely ignored the fact that Talcott made a factual finding that the state bar investigators had submitted false documents, false declarations to him. To this date, as of this date, they have not withdrawn those declarations.
Henschel was asserting that trial counsel withheld evidence of the felony arrest and conviction of another state bar witness.
You're supposed to tell the other side about felony convictions because it goes to witness credibility. When I found out about this, her being a witness, they were supposed to tell me about her conduct. And after this was all over, I just had an investigator run a rap sheet on her at his suggestion. And I found out that she had a criminal felony conviction of felony assault, of taking a razor to another prostitute's face, and that she'd been working as a prostitute at a bar.
He wrote a letter asking to address the Board of Governors Regulation and Discipline Committee about whether or not the use of perjury is a recurrent circumstance, tactics used by the state bar discipline system.
You have a First Amendment right to petition government for a redress of grievances.
Some observers also ask, Should lawyers not be encouraged to make reports to the State Bar Board of Trustees if the discipline system is not functioning properly? Is it right to punish a lawyer for making such reports?
He wrote multiple letters to the State Bar asserting that there's no State Bar membership status known as not entitled to practice. I'm an inactive member of the State Bar, and I should be listed that way in your records.
Judges had written to them and asked about it. See now, when judges are writing about their membership status, they're okay with that. But when Brad Henschel writes about his membership status, well, we've got to stop this guy. He can't practice law. Anyway, he says, membership status in the State Bar is currently defined by Business and Professions Code Section 6004 and 6005 to be either active or inactive. That's it. There's only two kinds. Creation of a special category would likely require a statutory change. In other words, a suspended attorney is like it says in 6126B of the Business and Profession Code. You're suspended from your membership. You're not a member of the bar when you're suspended. And every single person that gets suspended for any length of time is no longer a member of the bar during that suspension period. But that would mean that they don't have any jurisdiction over you, and they would lose jurisdiction over you for probation purposes too, because they're a corporation, and they only have jurisdiction over its members.
Petitioner further argued that State Bar Court judges were referees, not judges, and therefore could not hear his petition without his consent.
In the case of In re Manny Rose, it says that State Bar Court judges perform no judicial functions.
When Brad made his legal arguments to the State Bar Court, the review judges clearly disagreed with him. But was it fair for them to keep Brad suspended because they had a difference of opinion?
Petitioner's censure of the State Bar extended beyond specific employees and to the judicial branch itself. For example, he asserted that the State Bar was an organization that had a history of not knowing what laws are proper and what laws are unconstitutional.
Lawyers aren't allowed to criticize the courts. They don't have the free speech rights of other people. So instead of gaining more rights when you get a bar ticket, you lose them.
Viewed in its entirety, petitioner's behavior demonstrates an inability to evaluate facts in the law competently and to draw appropriate inferences and conclusions from them. The record clearly demonstrates that petitioner is unable or unwilling to conduct himself in a manner consistent with the settled definition of good moral character.
But earlier in the opinion, the review department described declarations submitted by 28 people, including 4 attorneys, who attested to Brad's good character and excellent legal abilities.
Many declarants provided compelling descriptions of how petitioner's legal service was invaluable to them because it saved their business or home or kept them or a family member out of jail. Many of the declarations contain laudatory descriptions of the attorney's capabilities and effectiveness in resolving difficult problems.
Critics argue that the Henschel case set a chilling precedent. A lawyer's value to the public means nothing in disciplinary matters if the lawyer persists in criticizing the thinking or conduct of bar officials. But even with this, the State Bar was not done with Brad. While he was entering the 5th year of what was supposed to have been an 18-month suspension, bar prosecutors filed new disciplinary charges against him. Unfortunately for Brad, Judge Talcott was no longer with the State Bar Court. The case was assigned to Judge Miles, who recommended Brad's disbarment. Brad once again found himself in the review department before the same 3 judges. They agreed with Judge Miles and issued their opinion on June 8, 2010. What had Brad done this time? While working as a paralegal for attorney Frank Williams, Brad had sent 2 emails to another lawyer whose client had just hired Mr. Williams to prepare papers for the federal court. Brad's boss needed the other lawyer's file urgently because of a court deadline. Brad offered to pick up the file personally, and he used words in the email that were intended to light a fire under the other lawyer.
It says it right here. Mr. Williams and I need your file. especially if you've learned something that should not be included in the writ we have been hired to write. If you also must be aware, failure to give a client this file to his new attorney gives rise to a cause of action for malpractice, among other legal ethical issues.
The state bar judges wrote that Brad's warnings to the other lawyer constituted the unauthorized practice of law. This meant that Brad was guilty of moral turpitude, even though he was motivated by a desire to help the client. Brad raised another issue in his defense.
Now, this was a federal matter. I was still a member of the federal court, despite what they did to me. I was still a member of the federal court. I was still a member of the tax court. I was still a member of the U.S. Supreme Court, and I still am right now. I was still a member of the Ninth Circuit. I was still a member of the Southern District Court of Appeal. I could practice in federal court.
The review department wrote that Brad's federal argument was unavailing because he provided legal opinions outside of federal court on issues of California law. But just 1 page earlier, the review judges wrote,
Henschel asserted that if the federal public defender had to step in, Rickard would be in trouble professionally.
Are federal court attorneys not allowed to discuss legal malpractice and the rules of professional responsibility without also having a state license? The review department also recommended Brad's disbarment because he personally signed a subpoena for a witness in his state bar case when he was representing himself. This was also deemed the unauthorized practice of law.
Only the clerk, a judge, or the attorney of record in an action may sign and issue a subpoena ducis tecum.
A clerk and a judge cannot practice law. Article 6, Section 9, California Constitution. And in the government code, it makes it a crime for a clerk to practice law. So the issuing of a subpoena can't be the practice of law.
There is a tragic irony in Brad's case. He wrote the emails when he was more than 3 years into what should have been an 18-month suspension. He would never have been accused of the unauthorized practice of law if the review department had agreed with Judge Talcott years earlier to let Brad resume his law practice, or if the 2-year suspension limit used today had been applicable then.
I cared. I cared about my clients. I cared about whether the bar was right or wrong and is screwing people right and left. Not just the lawyers, but the general public on top of it. They're running a scam, and it's got to stop.
Where is the California Supreme Court in all of this? The state bar is, after all, nothing more than the Supreme Court's administrative arm. Some critics joke that the state bar is more like a severed arm in a B-grade horror movie that is running amok under the noses of the Supreme Court justices. The Supreme Court discussed its role in discipline matters in the case of In re Rose. The majority opinion, written by then Chief Justice Ronald George, stated that lawyers in the discipline system receive adequate justice even though most of them never get to talk to a real judge. But 2 associate justices disagreed and wrote dissents.
History has produced less in the way of judicial protection for lawyers than our statutes give to, say, veterinarians and cosmetologists. Other professions get both a full plate of administrative due process and real judicial review before honest-to-God judges. Attorneys are the only persons whose state occupational licenses can be revoked or suspended without a judicial hearing. When the right to continue practicing a trade or profession is at stake, only attorneys are denied their day in court.
We have sometimes used humor in this program to tell the story of the California State Bar. Many people report a level of devastation to their lives that is no laughing matter. Betsy Warren Lebos, who goes by the name of Liz, has witnessed that devastation firsthand. She began her interview by telling us about building her legal practice after law school.
I eventually started my own practice in San Jose, and it became the largest divorce practice, family law practice, in Santa Clara County. I had 5 full-time employees and 5 part-time employees. I wrote about 7 articles on family law, and I was a notable family lawyer. I was a speaker and a presiding mentor to the California Trial Lawyers Association panels on family law.
Liz had a couple of encounters with the state bar discipline system when it was still being run by volunteers. The charges were all dismissed. Her real problems began in the mid-1980s after she earned a large fee award in a divorce case that attracted a creditor.
And that caused an attorney who had a breach of contract action against me for $13,000, which was on appeal, to feel emboldened to go to a judge in chambers with no notice to me and have a claimed receiver appointed. This receiver was subsequently sent to state prison. He went to the post office and he changed my address to his address. He stole all my credit cards. He stole all my money in my bank accounts. He stole my client's mail. We appeared before the judge. He laughed. He thought it was funny. And he is Conrad Rushing, who is now the presiding judge of the 6th Appellate District Court. I then went to the federal court. I remember walking out of the court. I had already prepared the papers, and I said, I'm going over to federal court and suing that judge. I went over to the federal court, and I filed a lawsuit against Conrad Rushing.
Liz filed her suit on October 3, 1986. The lawsuit challenged the ex parte procedures of the Santa Clara County Superior Court, so Liz included the other county judges as defendants. 2 weeks later, she was in Judge Rushing's courtroom asking that he disqualify himself from the case in which he had appointed Alan Munn as receiver over her property. The judge refused to do so. Liz then verbally challenged his decision in the courtroom.
He threw me in jail for contempt of court. And the headlines in the San Jose Mercury News was Judge jails lawyer who is suing him. When I got to jail, they put me in protective custody as an attorney, which meant that I was put with the women who were accused of molesting or killing or harming their children, which we had these red jumpsuits. Normally, you have an orange jumpsuit, but the ones who are hated the most are the ones with the red jumpsuits. The guard came and she said, the sheriff wants to see you. And I thought, oh God, more trouble. Turned out the sheriff was laughing. He was laughing. He says, I hate Conrad Rushing. He's now gone as the sheriff. I hate Conrad Rushing. And he's really a bad judge. But you've proven it. You sued him. And anyway, he said he offered me any amenities that they had. If you want any extra phone calls, if you want any extra food, if you need anything, Kotex or whatever, do you need anything, just let me know. So then I think 3 days later, he called me back in and he said, look, my jail is not for lawyers. You're visitors, not inmates. And I'm not going to have lawyers in my jail. He said, I'm releasing you because we're overcrowded.
Judge Rushing's contempt order against Liz was reported to the state bar. Formal disciplinary charges were filed in March 1988. A state bar court trial was held later that year before an assigned referee. Other charges were added, most of which were allegations that Liz had engaged in offensive conduct toward several Superior Court judges. After a 5-week state bar trial, the referee filed a decision on January 9, 1989, recommending that Liz be disbarred. The review department upheld the referee's recommendation. She appealed to the California Supreme Court, which agreed to hear her case.
Anyway, I looked at this system and I said, I remember back in law school, the United States Supreme Court said a mayor who sits as a judge in traffic court cannot find people guilty in order to get money to finance his village's activities. That's exactly what is happening here. That, in point of fact, the state bar prosecutes, finds, and has its judges find lawyers guilty in order to get monies to pay its own salaries and its judges' salaries and benefits. So I presented this issue to the California Supreme Court, and I said, well, you appointed these judges to sit, knowing that they need $1 million a year. And you know by finding every lawyer guilty, you're going to be getting the $1 million to pay their salaries. So you have to disqualify yourself from licensing lawyers. You have a conflict of interest. You're sitting in an executive role to the state bar, which is the prosecuting party. You're sitting in a judicial role deciding the guilt of the person who's going to be paying the salaries of your employees, of your appointees, actually your appointees, if you find them guilty. So of course you're going to find every lawyer guilty. You're disqualified under the law. Based on that motion to disqualify them, the California Supreme Court had its clerk call me up and tell me to shut up about their financial interest or be disbarred. It was said in nicer language than this. She said, the court would like to inform you that the issue of the constitutionality of Section 6079.1, Section 6086.10, Section 6086.65 are not on calendar, and you are not to mention them. When I got the phone call, I was in such shock I started shaking like a leaf. Leaf blowing in the wind, in the eastern wind in a storm. I was shaking so bad I couldn't stand up, and I couldn't even sit down because I was shaking so bad. I was absolutely flabbergasted at the corruption of the California Supreme Court. Anyway, I was tortured because I had always believed in the law. The next morning, I had my decision made that I could not be a lawyer licensed by this California Supreme Court. And I called up the court and I said, please inform the court I will not remain silent about their disbarring and suspending lawyers to get cash to pay their own appointees. Justice Broussard was on the panel, and when I went into the oral argument after telling them I was not going to remain silent, they gave me the stoniest, cold fish looks imaginable, except for Justice Broussard, who winked at me. It turned out that Justice Broussard had resigned that morning as a member of the California Supreme Court. Justice Broussard subsequently died, but his wink at me I always remember as the one light in the dark tunnel.
Liz survived her ordeal. She looks back on another lawyer who was not so lucky. His name was Robert McNamee. He had been referred to Liz for assistance by Father Raymond Dunn, a Roman Catholic priest and attorney.
Father Dunn told me that Robert McNamee was in his 70s, that he was a devout Roman Catholic, that for the entirety of his life, as long as he and the other Catholic priests could remember, he had always attended daily Mass at 7 o'clock in the morning. He was married to the same woman for over 50 years. He had grown children. And he had practiced law for over 50 years. and he had no prior record of any kind. Which meant that he was as decent a lawyer as there could be. No prior record for 50 years. Father Dunn told me he did a lot of pro bono work, which meant free work for people who were not fortunate. That, so he did a lot of good for the community. He helped a lot of poor people free of charge. He helped a lot of people with no complaint ever against him. And he was loyal and faithful to his wife, and good to his family and his clients and to everybody. He was a good man. He had mentioned to a client that there was a limited partnership that he had invested in that appeared to be a good investment. He was not a principal in the partnership. He was a limited partner, which meant he had no control over the investment. He was just an investor, like, holding stock. Apparently, this investment went bad. The client sued attorney Robert McNamara, claiming he gave her wrong advice. The lawsuit was pending. The State Bar of California brought charges against this good man and attorney, claiming his giving her investment advice was an act of moral turpitude. And I can recall that his being alleged to have committed an act of moral turpitude was like saying to this wonderful good man that he was a sinner. He was tormented and tortured by the false accusation against him. I remember for 3 days he slept on the couch in my home while I did the research in the papers to prepare for the California Supreme Court. He said that he wanted to take the papers himself to the California Supreme Court. And he took the papers up there from San Jose to San Francisco. As he walked through the door to file the papers, he had a near-fatal heart attack. I saw him at the hospital after he had to have, I think, a quintuplet heart bypass. And he was a defeated man who questioned whether there was a God. And 6 months later, he was dead.
Another known lawyer death connected to the State Bar occurred in 1995. James McDaniel was facing disbarment on allegations that he had committed sexual misconduct with several female clients. Not only was he facing State Bar charges, he had also been going through 8 years of civil litigation with the alleged victims over these matters. To McDaniel, it all seemed relentless. On the day set for his state bar trial, McDaniel killed himself with a gunshot wound to the head. His attorney said afterwards he saw himself in a box because it would never stop. Is it possible that the state bar is contributing, even in a small way, to the high rate of attorney substance abuse, clinical depression, and suicide? Dr. Karen Huffer is a licensed therapist. She is also a Title II and III specialist under the Americans with Disabilities Act who provides courtroom support for people with disabilities. Dr. Huffer has studied how litigation affects people psychologically. Her book, Overcoming the Devastation of Legal Abuse Syndrome, has received national attention.
When I realized that my clients who were in court did not get better, the same as those who were not involved in the court system, I began to look at the courts and wonder what happens to a person during litigation. They are re-traumatized over and over again. You can treat the trauma. They get better temporarily. Pretty soon they're back in court reliving the trauma, and they're back to me with the same symptoms. I also found that enough years and enough pain in the court could create the symptoms of post-traumatic stress disorder. What is being fed into the committee now by such researchers as Bessel van der Kolk, Judith Herman, is that there's also such a thing as complex post-traumatic stress disorder. And that has to do with those symptoms emerging over a long period of time rather than one acute event like an earthquake or a bomb blast or that kind of thing. So no matter how you cut it, your entire body, your hormonal system, all your physiology, and very often parts of anatomy are affected because of the somatic results of traumatic stress. We cannot be driving traumatic stress on one another as strategy or as policy. It is a public health menace if we do. The writers of the DSM-4 also put in global assessment of functioning. That means how did you do, how are you living, how effective were you at whatever you do before the event, and how are you now during the event? And it's rated on a scale of, about 40 to 90, 95 that most people use. My clients will have rated very highly before their court experience. During court and after they have been in it for a while, they'll sink 30 points. And legal is one of the stressors that are mentioned. So when I sit in these courtrooms and I watch what goes on, I watch my client suffering, struggling to talk, attempting to get a case heard. I look across the way, and in some instances, I see lawyers in trouble. I see them with flushed faces, anxiety that is obvious. I had one that was taking downers in order to get through the court day. I see everybody in that courtroom is suffering. I see judges not wanting to hear it all. It's too traumatic and difficult. They sit in a room with no windows, most of them, behind a bulletproof bench, and they hear lies and stories and trauma and attack and people not getting along all day long. It's a very difficult environment at best, but what we need to be doing is defining better. We need better language. We need better communication. We need better understanding of the dynamics that are going on that truly is creating a public health crisis. I see it coming just with the statistics of the legal profession and how they're succumbing to substance abuse, depression, high suicide rate, very, very difficult. It's a matter of the condition of the justice system that has allowed, almost like it has a host toxic parasite eating away at it. And over the 20 years that I've been studying it, actually more than 20, I've watched it deteriorate dramatically. I've watched the health and the behavior of lawyers deteriorate. I've watched the impatience of judges deteriorate. Some are wonderful. Some don't want to see you come in the courtroom. A while back, a fellow named Maslow made a hierarchy of needs that every human being needs. And it starts with air and water and food, and it works its way up to self-actualization. And safety was one of those on one of the rungs. And I added to that psychological safety. If we're to be balanced as a society, and if we're to feel safe in our culture, we have to know that there is a place where human beings attempt to achieve justice. Justice is a real human need. And we don't anymore go out and shoot somebody, or we shouldn't, who has made us angry. We take it to court. We take issues to court to get justice. When justice is not there, it absolutely undermines our entire sense of safety about our culture. And if you're already feeling helpless and in jeopardy, which is the formula for post-traumatic stress disorder, and then you feel jeopardized because the rules you read about the court, the way you were told the court should be operating, is not what's happening. It's not providing justice or even a chance for it. Hans Seeley said that there is something called basic trust, and if we don't have that in our society, the society cannot stand. We must be able to trust when we go to the grocery store that what it says on the label is what's in the can. We have to be able to trust when we hire a professional that they abide by a set of ethics. We need to trust our judges that they abide by their canons and their oath. And an oath is a promise. And if you don't make me a promise and you've got that much power, how do I trust? Sometimes people will attempt to use the court as a weapon to plan and execute the destruction of another person if they don't play by their rules, if they don't stay hostage to them. In a professional setting, if there's a professional discipline issue, it depends on the politics going on, but sometimes the disciplinary board, again, is used the same as the court, as a weapon, where someone will either lie to them or someone on that board may want to destroy another person for whatever purpose. And they will institute false actions or questionable actions in order to bring that kind of pressure on the other person. The other thing that happens with prosecution, which is really interesting to me, is that they will do everything in their power to get a person to plea, even if the person swears they didn't do it. And you hear about conviction rate and how someone's career success is measured by conviction rate. I think we need to rethink that too. The problem when a prosecutor will take that attitude that they can't be wrong and they don't have empathy or conscience are the kinds of prosecutors that when the Innocence Project brings them proof that the guy didn't rape the woman because the DNA proves it, and they say, no, we're not going to undo that. That is beyond my comprehension. That, in my opinion, is legal abuse. When you have a situation, I had a little girl who falsely accused her father of sexual misconduct. They threatened him and intimidated him, the prosecutors did, until he took a plea because he was afraid to go, of what they had told him. After he was in prison and serving 10 years, the little girl confided to me. I checked it out. I contacted the prosecutor and told them that she had recanted and that I thought they needed to take a second look at this. And they said, nope, he did the plea, he admitted it, that's it, stays on the record that way, and there was nothing they were going to do about it. I thought that was legal abuse. We're human beings. We make mistakes. And if we make a mistake that is costing another person years of their lives, we need to be looking at it. By the same token, I appreciate the tough prosecutors that are getting bad guys off the street. So we have to accept a certain amount of error, I think, there. But then once the error is pointed out, what does it cost them to take a second look at it? It's what one human being, how cruel can one human being be to another? It's man's inhumanity to man that will really stay with clients for a long time.
The producer of this program invited representatives of the California State Bar and Supreme Court to be interviewed so they could share their perspectives, but they declined. We asked the people interviewed for this program how they would change the State Bar. They offered a variety of opinions.
And eventually, someday it's going to happen, whether it happens through some great scandal or if someday the legislature just wakes up and says, this is crazy keeping this way, and just splits off the two groups into a regulatory body, and then there's a California Bar Association, a professional association of lawyers. Someday it's going to happen, but so this is part of this long trail.
Other people have proposed that lawyer regulation be placed under the Department of Consumer Affairs. This agency regulates more than 36 other professions, including doctors and accountants. Why not also attorneys? Another popular idea was to abolish the State Bar Court and let the Superior Court deal with attorney discipline cases.
A Superior Court judge, certainly, assuming, hypothetically, that the state legislature and governor appropriate sufficient money for operation of the judicial branch of government, Superior Court judge could do that and could be assigned full-time for that purpose, or maybe a couple, depending upon the county population and specifically the population of lawyers who are practicing in the courts. I think it would be an interesting responsibility, and there are other instances of it. Statutorily, every court is supposed to have a California Environmental Quality Act judge. Now, not all obey that statutory requirement, but trying cases under California Environmental Quality Act is interesting. I've done that, and I could readily accept an assignment just to handle those kinds of cases. And of course, in the large courts, assignments change either every year or 2 years, 3 years, the case may be. So statutorily, you could establish a system in which the Superior Court presided over disciplinary proceedings.
I'm in favor of, instead of like 12 people in the jury, I don't want to drag too many of them out there. We need, say, a 4-member jury system. In civil cases, it's got to be 3/4, like 9 out of 12. I would have the same thing in this 4-person jury system, where if the state bar wins, they have to get 3 out of 4 jurors.
I think at first blush, a lot of lawyers would be afraid to make a transition into the Superior Court. They think, oh my God, if we have lay people sitting on these little juries, like for example, if we use juries of 4 people in discipline cases, then the fear is that you'll get all of these public out there who don't understand what lawyers really do, who are maybe lawyer bashers. They've heard all these bad things about lawyers and they just can't wait to get in there. That's not my experience with lay juries. I generally find that there's a common sense to them that is very refreshing. So I think the lawyers would actually benefit because the jurors have no self-interest in the outcome. In other words, they have no monetary interest. Their jobs don't depend on it. And I think that's very, very important. Lawyers will appreciate that. I think the main thing, though, is that the lawyers then will have a right to appeal to a true court of appeals. I mean, the real court of appeals that hears appeals from the Superior Court. What that does is it puts a real rigor on the Superior Court judges. A rigor that the state bar court judges now lack because there really is not that true review. The California Supreme Court just doesn't get involved. So there's really nobody who puts that kind of discipline in on the judges below them. The review department and the hearing department of the State Bar Court really seem to act in concert more than being true independent bodies. They're just simply two departments of the same court, paid by the same California State Bar Association employer to get tough on lawyers. They're all under this mandate to get tough. They're all under the same pressures from the legislature to appear tough on lawyers, to discipline a certain number of lawyers. I think they maybe don't keep a statistic, but if it appears that they're not disciplining enough, they could lose their jobs. But with a jury, that doesn't happen. And with a Superior Court judge, it's not going to happen. And with an appellate court, that type of pressure also will not happen. And that makes it much better. It is also better because now the public is also directly involved in deciding lawyer discipline cases. Now you have members of the public sitting there in these little juries in the Superior Court deciding if a lawyer is to be disciplined and perhaps how much they should be disciplined. Well, that's about as direct an involvement of the public in lawyer discipline matters as I think you can get. And that's a big improvement over, I think, what we have now for both the public and for lawyers. Believe it or not, I think the lawyers will get a much better quality of justice. I think the lawyers that are being unfairly targeted will actually not suffer as much under a true jury system or under a Superior Court jury system as they do now under the State Bar Court system.
And I submit that you say, well, lawyers will abuse the jury system. No, I don't think so. No, when you have the State Bar prosecutor standing up there and say he ran off with the money of this client, I don't think this, I think most attorneys who have done wrong are not going to invoke the right of jury. Those jurors will throw the book at him or her. But for someone like me, I'll take my lumps with the jury.
By all indications, the California State Bar remains unpopular with the public and the profession. The mistrust that it earned in the late 1920s and early 1930s has never gone away. It is often viewed by the public as an ineffective watchdog, and by many of its attorney members as a clique that is more concerned about self-perpetuation than the public good. The result is harm to the justice system of California. Many people argue that major change is needed too, so that everyone can enjoy a happy ending to this story.
Here we go. Yeah, should have known it from the very start. It's with a broken heart. I listen to people